Evening. Can you all hear me? Okay, good. Okay, today is Monday, December 1st, 2025, and this is the Zoning Board of Adjustments. I'm going to open the meeting at 6:10, and the roll call is Suzanne Ryan, Chair, Audrey Klein, Vice Chair, Chuck Sumner is our clerk, Kate McMahon, and this evening we have one of our members, Jody Persons, who's been excused. In his stead, I will be appointing Sabette Stroman, and I don't know what I did. Oh, here it is. So we have a member who is out of state and unable to attend tonight's meeting in person. We have her here via Zoom. Under the right to know law, a member of a public body may participate in a meeting remotely only when such attendance is not reasonably practical. A quorum of the board is physically present here tonight. I will entertain a motion to allow member Sabette Stroman to participate in the meeting remotely, as it is not reasonably practical for her to be in physical attendance this evening. I will take a roll call vote. Audrey?
So moved.
Make a motion?
So moved.
Audrey?
Yes.
Kate?
Yes.
Chuck?
Yes.
Ryan, yes. Okay, so the minutes will reflect that this was not reasonably practical for member Sabette to physically attend tonight's meeting as she is out of state. All votes will occur by roll call vote as required. Member Sabette, please identify any person present in the location from which you are participating. Is there anyone in the room with you?
No.
For the audience who may not be able to hear member Sabette clearly, please feel free to move your seats forward as much as necessary in order to impose a point of order if you are struggling to hear Sabette. So just to be clear, voting members tonight are Audrey Klein, Kate McMahon, Chuck Summers, Suzanne Ryan, and I appoint Sabette Stroman in the place of Jody Persons. Also tonight we have with us the interim town planner, Shauna Saunders, and our attorney Michael Maglione. Okay, with that said, the agenda tonight. We have 4 cases that may get continued. We have, Chuck, we have done the site visits on all 4 of those, and before we open each case, I'll ask you to read the synopsis of the site visits. Minutes of previous meetings, I don't think anyone's had a chance to review those, so if it's okay with the board, I'll skip over those. And we'll go right to number 4 on the agenda, which is a motion for rehearing the Feder Family Revocable Trust, 2018, 12 Elm Street, 20468, consideration for a motion for rehearing for a variance of Atwell on Elm LLC, case number 11V25 for property at 14 Elm. And this is a public meeting, not a public hearing. And as such, we are not required to take public comment. The purpose of the board this evening on this application is to determine whether or not we will or will not rehear that case. Board members, let's have some discussion as to whether we will or we will not hear the case. And by the way, just so I explain to the public, if I can find it, rehearing. The initial reason that we have to waive, whether it be here or not, is if we have made any legal or technical error or not a reasonable that is not a reason that is not reasonable to have come to our conclusion. So, and we're not going to argue the legalities that have been pointed out to us by the applicant and the abutter. We're going to just determine from our own experience, having gone through the hearing, if we feel that that we made a legal or technical error or an unreasonable error. So, since I was the one that voted not to rehear, and I feel that we missed out on an important part of the conversation, which is, I don't know if I can find it. In our definition of our zoning ordinance, we have what's called non-conforming uses, non-conforming structures, and non-conforming land. And in our definition, it's always prefaced by legally non-conforming, legally non-conforming use, legally non-conforming structure, and legally non-conforming piece of land. We know from the testimony given in our big, thick application that the person that is Mr. Fetter is requesting a rehearing. That's one of the points I believe that he's brought up. And I feel that we misinterpreted non-conforming by not prefacing it with legally non-conforming, and that was an error. And I think the case should be reheard on that point. And then I also feel that the zoning map, 2012, it was stated, and I'm sure it's reflected in the minutes, that, well, you know, there's a mixed use all around that area. There is a mixed use, but not in that zone. It's a specific zone around the whole water area for shorefront residential. And it's this green squiggly line. Okay? And just so happens that that green squiggly line runs right along the applicant's parcel, as in included in that parcel. And that is shorefront residential. And the reason that people may have thought, oh, well, they do this across the street, and they do this on Pine Hill, and they do this on Center Street, and I see it everywhere, the mixed use. Well, that mixed use is allowed in those zones. But where this green is on Back Bay, it's not allowed. That's a residential zone. And mixed use and commercial use, which this is not allowed. And I think we made an error in taking a visual of how we thought the neighborhood looked. This is it went from a retail to a personal service, and that is a use that is not allowed in that zone. So, anybody else want to weigh in?
Yep.
Kate, speak up loud into the microphone.
Okay. That particular site has, for at least 50 years, been a mixture of residential, and that building, particularly the Atwell building, has been mixed. It has been a commercial facility in that zone for at least 50 years. So I don't think it's a matter of, well, across the street it's commercial. It's been, that particular property has had commercial interest for all these years. I think also that I read back through to see if I could find technical errors or factual errors in our deliberations. I read the minutes. I reread the extensive application from the abutter and read all the material. I couldn't see that we had made a mistake. We went through the criteria for a variance conscientiously. We had a good discussion. I think that the case is made for a variance, and so I'm very much opposed to a rehearing.
Okay. In your reference about for 50 years it's been what it is, I will point to you that the planning board has had this discussion on this particular area, and I think it was Becky Swarfield, either she was on the planning board or a member in attendance, and it was talked about when the clickety-clack was being discussed. The clickety-clack, by the way, wasn't retail, it was a they call it a museum, but it really wasn't even a museum. They never sold anything there. It was just a display. The planning board entitled it a railroad display. And when the planning board was talking about this, she said, for years we have tried to rezone this because it was residential. We've tried to rezone this to include what you've described, and the people didn't vote for it. The people did not vote to have it rezoned. They kept it this way. So I don't think that argument holds.
It was also a retail establishment. It was an antiques business at some point.
The antique business, I don't believe that they got the full approval for running a retail business there. However, that's not the question before us. The question before us is personal service. That is not, it went from, if you even say retail was allowed by, which I don't believe they were, I don't believe they got the proper permits to do that. When they sold the property to Atwell, it went to personal service, which is not retail. It's a commercial operation.
It's commercial, though.
For which, on the application, she applied for personal service acupuncture, and as it turns out, she sublet or has contract for a studio for enlarging, expanding the use that she applied for. And that was not what she applied for.
I think she applied for a clinic and a studio.
It was not on the application for applying. No, it was not. I see Audrey chomping at the bit.
No, I want you guys to finish your discussion. So, when you say it's not legally non-conforming because you don't believe it went through a process from one commercial enterprise to another commercial enterprise, and you're saying that's why it's not legal?
Yes.
Okay. So, in my opinion, it did go through that process. There is no formal process in our zoning that says you have to go for a special exception or a variance if you change the use of that building under the non-conforming section. The non-conforming section says you can have the same thing or something that's less non-conforming. It doesn't say how you determine what less non-conforming is. What it says is, it kicks the door open and it says to the code enforcement officer, you decide what's less non-conforming and whether that's going to be legal, and if you don't think it is, you send it for a variance. Neither of the code enforcement officers, building officials who gave these permits sent it to the ZBA. They felt it was less non-conforming than the original approved use of a museum. So in that sense, I believe that these are legally non-conforming. They were approved by the person that has a discretionary judgment to decide whether they're less non-conforming or equally non-conforming. And yes, they did apply for a studio. It's here on the floor plan. It was very well vetted through both the building and the fire department as a studio. And I think looking back, I would say I think that their decisions are defensible because the actual impact of the uses of those changes are not higher than what was there before. The number of people that can use this latest acupuncture and studio space is only about 20 people, which is not that much of a higher impact than what could have, should have, and I'm sure would have hoped to be a very busy antique store or a museum, which could be even higher. So I think those decisions are defensible, and I think this is legally non-conforming. So I also think I agree with Kate on all the other points that we really did a thorough job at looking at the other issues for the variance.
Okay, well, legally non-conforming is, should the zoning ordinance change, and they were legally operating and non-conforming at the time. The zoning never changed here in this district, in this, what is it, the village, shorefront residential district. And the expansion of that use is, you just can't haphazardly expand a non-conforming use. You have to go for a site plan, and they didn't go for a site plan.
They who?
The applicant.
This applicant? Atwell applicant?
Yeah.
That's why we're here. They did go for a
Well, and
site
that's what
plan.
I'm saying. They missed that step, and and they are illegally non-conforming. They're not illegal. The zoning, it's when the zoning changes is what makes something non-conforming. The zoning didn't change.
So
They have
originally,
expanded to a great degree, which affects the neighborhood.
okay, so that's where we disagree. I don't think there was an expansion. I think that they fall under the original non-conforming impacts of the area.
Well,
And I don't believe they expanded the business. They went for
Well,
a
it's a-
parking lot, which is an accessory to the business, which was approved in the previous plan, and accessory uses are permitted.
but it's a change of use. It isn't an expansion. It isn't an expansion of the antique shop that was retail. It's a change of use from retail to personal service, and that change of use didn't receive site plan approval.
So I think, I don't think with the other paperwork and approvals by the town that weighs it on that side for me. I think that it's legally non-conforming because of the decisions that were made during the switch from the museum to the retail and from the retail to the personal service. They were all under the less non-conforming hat.
But it
And
was
they
a
didn't need
change
to-
of use
they-
from
they didn't
retail
need
to
do-
personal service, and
they
it
didn't
missed
do
a
it-
step.
They didn't need to do a change of use because it's non-conforming.
Okay. Chuck, you want to weigh in on this?
Yes, I'm going to agree with Audrey in that it's a non-conforming use, but the change of non-conforming use was something that when we reviewed the application for the building permit and so forth, it was decided at that time that it was not an issue. And I'm going to agree with Kate that I too have gone through and spent a fair amount of time going through the entire case again, and I don't see that we made any errors, either technical or legal, in terms of our review and our decisions.
Okay. Sabette, do you want to weigh in, or?
I think that I tend to agree more with Suzanne And my concern is that the expansion has been significant. I don't agree with Audrey when she says 20 cars or whatever is only slightly more significant than Clickety Clack or the antique shop. I'm not sure I ever saw more than one car in that parking lot. And I think I'm not sure technically whether you can say personal use versus retail, how much of a change of use that is. But this particular change in use has significantly increased the amount of traffic to that site, and that concerns me.
Thank you, Sabette. Is there any further discussion? I make a motion to rehear this case because I feel that we have made a technical error in so much as we didn't address the change of use, the zone that it's in, and the expansion of the use. Do I have a second?
I second.
Roll call vote.
Audrey, no.
Kate, no.
Chuck, no.
Ryan, yes. Sabette?
Yes.
The motion fails. Anybody else care to make a motion?
I make a motion that, well, do we have to make another motion?
Yes.
Yes.
Okay, I make a motion that we deny the motion for rehearing.
Is there a
Second.
second?
Yes.
Roll call vote.
Audrey, yes.
Kate, yes.
Chuck?
Chuck, yes.
Ryan, no. Sabette?
No. No.
Okay. That ends this case. The second part of this issue with Elm Street is a, let me just put this aside. Put this aside. Put this aside. What did I do with my agenda? Thank you. The second part of the Elm Street
Do you want me to read it?
issue is an appeal of the code enforcement officer's failure to enforce the zoning code 17565, appeal filed by the Fetter Family Revocable Trust, 2018, 12 Elm Street, 20468, regarding the property of Atwell on Elm LLC located on 14 Elm Street per May 28th, 2025 complaint. So it was a complaint for lack of enforcement, and we have sat with our attorney on this, actually both of them. They're not easy cases, for sure. I believe that the proper time frame has been met for this application to be filed. Is that correct, Michael?
In terms of the proper timeframe, that's a determination for the board to make. I'd be happy to advise further on that, maybe if we stepped out, because that didn't
Okay.
come up previously.
Yes,
Well,
I would like to step out and discuss the time frame.
You accept the time frame?
No, I would like to step out and discuss the time
Oh,
frame.
okay. All right, we're going to have to take a brief 5-minute break. What was that statute, 674 what? Downstairs in Taylor.
676.5.
What was it?
676.5.
Is he here?
I've got it here marked. 676.52B.
I'll go talk to him real quick. Can I have 1 minute to talk to somebody in the audience?
See what those- some of these-
So,
Oh, you have it.
oh, before I open it. 676. 676.5. Have you got that paperwork? Have you got the paperwork on jurisdiction?
Yes, sorry.
Thank you.
Thanks. It's a long form.
Yep, it doesn't square the circle, but
No.
it's not on here. It would be, a legal issue, and it's not on here.
Therefore, so it's 4.
Impervious.
Thank you. Is that yours? Okay, call the meeting back to order at 6:45. Okay, so what we've determined is that timeliness is not the issue here. And what we have instead is a decision to make whether or not we have jurisdiction under 674-33, 676-5, specifically whether this involves the discretionary decision to commence enforcement proceedings. And to that, I will take public comment
The applicant.
from the applicant.
Oh, I'm sorry, right. Yeah. Yes.
Applicant first and then the landowner.
I have a few exhibits I'd like to hand out.
Oh, great, more paper.
I need one to go for the record. This is what she's handing out. Oops, sorry, it's upside down. Yep.
Thank you.
Thanks.
Yeah.
What is this?
Okay, here's the last one.
Are these the same? No.
Wait, I got this.
Yeah, so there's 4 handouts coming.
Okay. Okay. And again, the public will have to excuse us for a minute while we digest some of this.
Thank you. One of these.
Not yet.
No, I'll come around. Oh, no, you hang on to that. I'm gonna
Okay,
come around and
thanks.
give Audrey hers.
Okay, thanks.
That.
Thank you.
So there's 4, yep, they look the same, but they're not, right? Yep. Two deeds look the same, but they're different.
I have no idea. Yeah, this is they're privileged, yeah. Privileged, yeah. So that doesn't belong in there.
You need copies too?
This is,
Yeah, that's what No.
it hasn't.
Go into the
Go ahead, yeah,
rules of procedure. First reading last month, or last meeting.
okay.
Yes. Is there more of these?
I gave my.
Over here, I've got it here, sorry, yeah, thank you. Okay. Oh, you do? Okay. Okay, perfect. Thank you.
Shauna, you said there were 2 deeds? Or are they both on the same sheet?
Nope, well, there were 2 stapled deed packages that look the same.
They're different.
They're different.
I only got one.
You only got one.
Oh, I'm sorry, here's the other one.
They look the same, but they're
Yeah, I
different.
got it.
And I'm not sure what the purpose is, but I'm sure we'll find out. Are you ready? And would you state your name again for the record? And speak. The mic's not on, they said. It's voice activated, so you have to speak right up onto the microphone.
How is this?
No,
Not working. Is this better?
that,
Okay. For the record, I am Rachel Hampy. I'm a trial attorney with McLean Middleton. And as you know, I represent Stephen and Suzanne Fetter, who are here tonight, sitting here to the left behind me. First of all, I want to thank you for granting me the continuance. I wasn't able to be here that night. Not only was I not able to be here, I couldn't speak. I had a wisdom tooth removed. And so at my surprising age for having to have that done, it needed to be addressed. So thank you for that. I have since listened to the recording of your November meeting and read the minutes of that meeting. And I want to begin where Chair Ryan left off regarding your proposed amendments to your section 11.18 rule change for your own rules. The timing of that is interesting, but as I understand it, you're intending to perhaps codify potential grounds for lack of jurisdiction. And those are not applicable here, and I'll address that in a minute. But as Chair Ryan stated at your last meeting, Rule 18 in Roman numeral section 11 allows the board to approve with conditions, deny an application, or dismiss for lack of jurisdiction. Tonight, we are asking you to approve our application seeking the enforcement of the town's zoning ordinance to cease the illegal, non-conforming commercial use of the Atwell property located in the Shorefront Residential District. This is not only something that you have both the statutory and procedural authority to do, it is something that you should do, because this problem was raised by this board at your April 7th meeting when you specifically told Atwell that it did not have the proper permits to be running the existing acupuncture clinic at this site in the residential zone. The use is therefore illegal and should be stopped. When the Fedders bought their property, which they intended to have as their retirement home and to use as a year-round property to enjoy with their 6 children, they had no way of knowing that this tiny lot that was then a quiet antique store would be turned into a much larger, expanded, and intensified commercial business. So tonight,
I can't hear you. You have to use the microphone. I can't, and state your name, please.
Roy Tilsley, I represent the underlying applicant, Atwell on Elm LLC. As I understood it, when the board opened this hearing to public comment, it was to be limited to the issue of whether the board had jurisdiction to hear this appeal. I think what the board is hearing now is their appeal and not testimony or evidence or argument on the jurisdictional issue, and therefore I'm objecting to going into the merits until you determine jurisdiction. Thank you.
Good point.
I'm here to address the entire application. I'm obviously going to address jurisdiction in my remarks.
Well, we've already made it, the point is taken. We've already made the decision of whether to rehear or not. You submitted 2 separate packets of information. One was for rehearing and one was for enforcement or lack thereof. And that's what we're on now, is the
Absolutely.
enforcement issue.
That's what I'm on here too.
So my understanding of what was just said is that we were questioning whether we had jurisdiction over this appeal of the non-enforcement.
Right.
And so we need to hear argument just on the jurisdiction before we hear the rest of the appeal.
Right, and so that's what I'm going to ask the attorney to do, is try and argue why you feel we have jurisdiction
That's what I'm attempting to do.
Over enforcement.
So you're gonna, okay. All right, so,
And you gave us this handout, which
Yes.
indicates that's what you'd be talking about.
exactly. So first of all, I wanted to bring up the proposed amendments to your procedural rule. Obviously, those haven't been voted on yet, but because you have them in mind, I want to address them. Specifically, you're talking about codifying 4 grounds for finding lack of jurisdiction. One of them, the first one, is material change. That doesn't apply here because there's no site plan or subdivision that's been changed. The second one is insufficient information, and that also doesn't apply here because we have plenty of information for you, and if you need more, we're happy to provide it. The third is lack of standing, and that clearly is not an issue here too because there's no dispute that the Fedders are immediate abutters. The last one is improper appeal process. There's nothing improper about this application, and in fact, the town compelled us to file it. Let me be clear, we did not want to have to file this application. We didn't want to be in this position to begin with. I can't talk about settlement negotiations, but I can tell you that my clients wanted to be good neighbors, and they tried to work it out, and they never wanted to be here. Second, the town has compelled us to file this application because it failed to take action. Not only did it fail to take action, it didn't give us the courtesy of providing us with a response. You have this correspondence in the record before you. Not having heard from Atwell, we filed a complaint on May 28th. We heard nothing, so we followed up with a letter on July 2nd. The town's attorney responded on July 10th, stating, quote, "I am currently working with planning and code enforcement to evaluate your complaint." That seemed like progress. That seemed like we were going somewhere here. But then we didn't hear anything. We filed again in September, on September 15th and October 22nd, and in the October 22nd letter, we requested a response by a certain date. Crickets. We heard nothing back. Ideally, and I say this because I'm a trial attorney who likes to go to court, we could have just immediately sued. We could have gone right to court. But as you all are probably familiar, there's a doctrine called exhausting administrative remedies. So if there's anything that's in your purview, the court requires us to present it to you so you can try to fix any problem before it goes to court. So looking at the statute, we were faced with what we had to do here to prepare for going to trial, if necessary. Looking at the statute, 674-33, it says the zoning board has the jurisdiction to hear and decide appeals if it is alleged that there is an error in any order, requirement, decision, or determination made by an administrative official in the enforcement of any zoning ordinance that's been adopted by the town. Here, the official is the code enforcer. Turning to the handout, and the decision here is what to do about this non-conforming commercial use in the shorefront residential district. Turning to the handout, RSA 676.5 says that any construction, interpretation, or application of terms of the ordinance implicated in enforcement proceedings are absolutely appealable. It says a discretionary decision to commence formal or informal enforcement proceedings is not. So discretionary decisions to enforce are not appealable. But what about decisions not to enforce, or a failure to even provide the courtesy of a response? There are some attorneys who believe, including Mr. Tilsley, that because the statute says that a decision to commence formal or informal proceedings is not appealable, that implies a decision not to enforce is not appealable. But the statute doesn't say that. And the Supreme Court has not addressed it. We took the unusual effort of going to look at a Superior Court file involving a case in Bedford where this issue was raised, but unfortunately, it wasn't decided. So there's no case law on it. And given the history of this case, and in particular, in our view, the treatment of my clients to date, we couldn't take the risk that we would proceed to court without first coming here to give you the opportunity to address it. We couldn't risk later having the town or the Atwells file motions saying that we failed to exhaust our administrative remedies to come here and give you the opportunity to fix it first. We especially couldn't take that risk in light of the fact that the board specifically raised this issue at its April 7th meeting when it told Atwell that Atwell did not have the necessary approvals to having changed the non-conforming commercial use of the antique store into its existing non-conforming commercial use as an acupuncture clinic and studio. Now, when that was brought up at the April 7th meeting, it was brought up by Member Klein, who couched it as bad news for Atwell. And there's additional bad news, and that is that we conducted an exhaustive search of the town's files, and we couldn't find any record of the antique store having obtained any permit to change the non-conforming use from the museum to the antique store. So here we have a illegal non-conforming use being changed to another illegal non-conforming use. And I handed out the deeds to give you the record for the timeline here that's important. It was the Clickety-Clack Museum, or display, as somebody mentioned earlier, from approximately 1981 to approximately 2019. Then, in 2019, it became the antique store.
Could I interrupt you just for a minute? So I keep going back and forth trying to understand, are you appealing the decisions of that time period in putting those businesses in, or are you appealing the decision or lack thereof of the administration now for not enforcing something that was decided then?
We're appealing the decision of the town to fail to act now.
And what is it you want them to act on now?
We want them to stop the illegal, non-conforming use of the current acupuncture and studio.
So you're making the claim that that's an illegal, non-conforming use.
Correct.
That's been going on for years.
No, so that's partly why I gave you the deeds. It was my client's bought, so it was the antique store in 2019. My clients bought their property in 2021. Then,
Let me just, I understand the timeline. So,
wait,
and I understand why you're doing this, because you need to make sure that you've gone through all the processes you need for a higher court. And that's what you just explained, and I understand that, and that makes sense. So what you're asking us to do is to make a decision that can be appealed one way or the other, because there's never been a decision on this the way you're presenting it, and so you need to present it, we need to make this decision, and the court's going to end up making the legal decision, whatever that is.
and just one clarification, though, on the timing, though, because the submission from the other side said that it's been this use since 2022, but the building permit and the occupancy permit for the current Atwell business is from 2023. And if I could go on about that, it doesn't even mention the studio use that's currently being used.
So again, you're bouncing back to decisions that were made before a time, I mean, much earlier on, and not within an appeal period at this point. Whereas this decision that you're asking about whether this section 676(5) applies to whether or not just a word, the decision to does not include or does include a discretionary decision to commence or not to commence formal or informal enforcement. You're simply saying that it doesn't say not to commence. And that's your argument, is this section, this RSA, is giving us the authority to hear this because it doesn't say not to commence rather than just to commence.
Right.
And that's the only thing we're hearing right now, is that specific wording, because that's what you're going to take to a higher court to decide whether that wording covers both situations or only that one situation.
Right.
So I don't think that, in my opinion, we need to hear the history about everything else that has happened if that's what you're appealing here.
Audrey, I tend to agree in that in the present day, the circumstances currently, the history is irrelevant at this point. You can't appeal what happened 10 years ago. Your issue, I believe, is the current non-enforcement of the acupuncture studio issue, not the clickety-clack and not the retail business. That's another argument. We need to hear from you why we should or should not take action as in the stead of the code enforcement. on 674-33. We fully understand all the other discussions that have gone on about how it's used and when it's used and why it's used and should it or should not be used. What we need from you is an argument why we should support what you're asking us to do. I don't think
So-
I've heard that.
Yeah.
Wait, so I'm sorry. So if you're asking me if I'm seeking to have, if we're appealing the failure of the town to act to enforce zoning code to shut down the illegal Atwell Clinic and Studio, the answer is yes. That's what we're here for. And so I was just trying to explain that we filed this pursuant to the statute that you just read that says that you can't appeal a decision, a discretionary decision to enforce, but it's not clear on a decision not to enforce. So we're appealing the decision not to enforce, or the failure to even act or give us a decision on the illegal, non-conforming use of the property now as an acupuncture clinic and studio. And so I think I've just restated what you both just said.
Yes, that makes it clear.
Okay.
What's happening now
Yes.
is what you're appealing, the lack of enforcement now.
And I could go on to explain why we think it needs to be enforced, but that's not related necessarily to jurisdiction. If you want me to address that later, I can address it afterwards.
So I think there's two levels. One, do we have jurisdiction under this RSA? We
Yep.
need to decide that.
Yes,
And then if we think we have jurisdiction, we hear the next level.
Yes.
So right now, we just want to understand.
You need to argue to us why we have jurisdiction.
Okay.
And I think,
So I think I just did that.
Yep.
So you have jurisdiction because you have the purview to review not just the decision, but the statute says actually determination. So here, there's been a determination by not responding to our numerous letters asking the town to enforce its zoning. I can talk to you about the hours of use and things like that if you want me to, but I can do that afterwards. But also, I just want to make sure that the timeliness issue is gone, because I have cases to mention if you need me to bring those up too, with respect to the alleged timeliness issue. Well, I think we're beyond that.
we're not taking that up.
Okay.
Non-issue.
Okay.
So I understand, what I understand is essentially this 676.5, I think it's 2B, not 1B, but so the first level is, do we think we have jurisdiction to interpret this, even though, because this says, does not include discretionary decision to commence formal or informal enforcement, it doesn't say, it does not include discretionary decision to commence or not commence formal or informal enforcement proceedings. So that's our first decision. Do we have jurisdiction to take this up because it doesn't say we can't take up a non-enforcement? And once we decide that, if we want to move on to the other, or, once we decide that, then we move on to the other half. I think, as the attorney mentioned, this has not been heard in the higher court. Either way we decide, it's going to a higher court. But I believe that this says that we don't have discretion. We don't have the jurisdiction to decide formal or informal enforcement, whether to commence it or not commence it. We simply just don't have jurisdiction.
So I do think before we deliberate, if we have any questions for Attorney Hampy, we then...
Well, I think you've explained yourself. Is there anything else you want to add before I open it up
If we're not going to address timeliness. Okay.
Okay.
It's a non-issue.
Yep. You have to reintroduce yourself. And then you need to argue why we don't have jurisdiction.
I understand. My name is Roy Tilsley. I'm an attorney with Bernstein Shore on behalf of Atwell on Elm LLC. The abutters position here, I think, fundamentally misstates the scope and authority of this board on an administrative appeal. First of all, you sit as an appellate board. There has to be a decision to review to determine whether the decision was right or wrong. Here, there is no decision of the code enforcement officer for you to review. Their application says so. On the administrative appeal decision, you normally attach the town's form that you get from the code enforcement officer where he or she either grants or denies the requested permit. Here, the abutter attached the form and filled in themselves, no decision. Let me quote it accurately so I don't get myself into trouble. Decision never issued. So there is no decision that they're appealing. Number two, if there is a decision that they're appealing, in order to appeal it to this board, it has to be a decision interpreting the zoning ordinance, because that's your authority. You have the authority to make appellate determinations on the interpretation of the zoning ordinance. It might be the code enforcement officer, it might be the planning board, it might be the board of selectmen. That's the authority that you have. We don't have a decision, so we don't know, as we stand here today, why the code enforcement officer did not take any action on their complaint. But we can't assume that that decision was based on the zoning ordinance. He may have other reasons to issue the decision. I've been talking in my several meetings here about the doctrine of municipal estoppel, which essentially says when a person has received and relied on permits and made substantial changes to their property, that a municipality cannot necessarily change their mind about permits that they've issued and revoke permits. It's possible. I don't have any insight that the code enforcement officer looked at this and says, you know, she got her occupancy permit 2 years ago. It's too late for us to change our mind, and I'm not going to take any action on this enforcement request. That would not be a decision that's appealable to this board. The Dembiek case is very clear that this board does not have jurisdiction over estoppel claims. And that would not be an interpretation under the zoning ordinance. You folks are not an enforcement board. You folks make decisions on variances, special exceptions, and administrative appeals interpreting the zoning ordinance. The town has other enforcement mechanisms to enforce the provisions of their ordinances, the provisions of their permits, and those actions are not reviewable by this board. You do not sit to review any actions, every action by the code enforcement officer, and you do not sit to enforce violations of the ordinance that may exist out in the field. You make determinations when things are brought before you on requests for relief or appropriate administrative appeals. I don't for a minute buy the argument that the language regarding a discretionary decision to commence enforcement proceedings means that the carve-out is only if the code enforcement officer decides to commence them, and there isn't a carve-out if he or she decides not to commence them. If there was a decision here, and I don't think there is, and that's the first step to having jurisdiction, if there was a decision here, the decision would be, I've looked at this, and I don't think that there's a reason to enforce the ordinance. That's a decision to commence enforcement proceedings. The decision is no, but it's still a decision. The statute doesn't say that it is limited to decisions where enforcement proceedings are commenced. It's a decision to commence. They asked him very specifically to commence enforcement proceedings. Nothing happened. There is no decision. Put that aside, though. They have to have a decision to be here. So if they say the decision is silence in an action, you have to accept that decision. And that decision is covered by the carve-out in the ordinance, which does not give you folks jurisdiction over this particular complaint. Your role is very clear. There has to be a decision. In this case, there isn't. And there has to be a decision interpreting the terms of the zoning ordinance. And in this case, there isn't. We don't know why the town hasn't taken action. As you've heard, they believe they can take this to court, and they may have other mechanisms available to them. But there is no jurisdiction of this board to hear this particular appeal. And I'd urge you to make that determination and not move forward. I do have other arguments to make. If you reach the merits, I'll reserve my rights on those if you decide to accept this and address you at that point. I'm happy to take any questions, and I thank you for your attention.
Board, any questions? No?
Thank you, folks.
No.
Thank you.
Thank you. Response, yes.
It's not your job to try to,
Put the microphone close.
it's not your job to try to assume things about municipal stop or anything like that. It's your job to enforce zoning. And that's what we're asking you to do. We're asking you to enforce the zoning ordinance in response of the decision not to enforce it. And I'd like to point you to my letter of October 22nd, 2025, where I wrote to the town and I asked them to tell me by a specific date if they were, I asked them to respond to tell me if they were going to give a decision. I said, if you don't respond to me by a certain date, my understanding is that you're exercising your discretion not to enforce. That's the decision. They didn't respond. They received my letter asking and confirming that they were making the decision not to enforce, and they didn't respond. So as of October 24th, 2025, the deadline, there was a decision made that they were confirming that they were not seeking to enforce the zoning ordinance. That's a decision. Now it's up to you to consider that decision because it's a zoning issue. We're asking for the zoning to be enforced to stop the illegal, non-conforming commercial use in the shorefront residential district. Do you have any other questions for me?
Thank you. Okay, I think we've heard enough from both attorneys, and that we have to make the hard choice.
Do we need to close the hearing?
I didn't open the
deliberations? You
hearing.
didn't? Okay.
It was public comment.
Yeah, we're still talking about jurisdiction.
Okay. Good.
And so we've got a handout here that actually we were working on our bylaws to better define what jurisdiction might be and what we might take up under or not under jurisdiction. And we have 4 items that describe the adjective jurisdiction, and one is no material change in subsequent applications. The ZBA can reject a new application for a previously denied project if there has not been a material change in circumstance or in the nature of the application. This prevents applicants from making the same request over and over. I don't think that number 1 applies. Insufficient information.
Madam Chair, if I may, sorry to cut you off, but I just, it may not be possible to characterize to put the jurisdictional issue that we're facing here tonight into one of these pots.
Okay.
It's a question of statutory interpretation. And so I think think about that in terms of the arguments that were presented, in terms of the language of the statute itself, and that's really the beginning and the end of the task. It's not to characterize it into one of these. Although they may be helpful in, sort of thinking about things, I think we just want to make sure that we stay close to the statute. And,
I think if we had to, it would be an improper appeals process because they're filing with the wrong body. We don't have jurisdiction. But I don't think that these 4 describe
No,
technical
number 3
issue.
does. They have standing.
Again,
guess
I don't
think
know
it
that
does.
we should argue those jurisdictional points.
Well, I'm not gonna use them as the basis, but I mean, I think it gives us an idea of what jurisdiction is. You know, I think it comes to number 4, is this an improper process for us to take up?
Right, I think
That's the key, that's the key right there. Do we have the authority to make this decision? I've always been taught over the years that, probably not a case like this, but that we stand in the stead of the code officer when trying to make a decision on their decision. But this is enforcement, which is not just them saying, I deny your request for a setback. This is a request for us to enforce. And I tend to think that we don't have the jurisdiction to literally issue a cease and desist order.
I agree. I don't think that section 676.5(2)B can be read to say if there is an action taken by somebody, that means that, you know, it's a decision. A non-action is a decision. I don't think that can globally be true, and therefore I don't think it's true.
Yeah, I don't, I think I might be misspeaking here, but I think by using experiences of other cases, when something is pending, it's like a stay. Think the movement forward on enforcement is a stay until certain things have been clarified. And in this case, I think it sounds to me like the town has taken the position until we get through the other application that was before us tonight. This is basically a stay, and that aside, if I'm wrong on that, which I probably am, I don't think that we enforce. I don't think we have that jurisdiction to enforce, especially a cease and desist order. If we were being asked to coach the code inspector along,
We don't coach.
you know, but no, I'm saying if we were to come to a middle road or something, then that might be different. But they're basically asking us to, think where they say here.
So can I ask Kate and Charles what their position is? Are you pretty much all set?
Yeah, okay, I'll go one by one. Chuck?
Yeah, no, I am of the opinion that we do not have jurisdiction.
I
Kate?
agree.
Audrey?
No, well, there's no motion, so.
Sabette?
I do not think we have jurisdiction.
Okay, then I would like to make a motion that we do not have jurisdiction to hear this case.
I will second it, Audrey.
Yeah, can we just have a little bit more discussion about specifically why?
Because 676.5 and 674.33 spell out the role that we have or don't have, and we feel that we don't have the role to enforce in accordance with the statute.
And so if I may, 674.33 says that the Zoning Board of Adjustment shall have the power to hear, and it would be great if we could hear and decide appeals if it is alleged there is an error in any order, requirement, decision, or determination made by the administrative official, of which there was actually none. And then The decision of the administrative official includes any decision involving construction interpretation or application of the terms of the ordinance. It does not include a discretionary decision to commence formal or informal enforcement proceedings, but does include any construction interpretation or application of the terms of the ordinance.
Okay, and so I'll add to my motion that we do not have the authority to invoke a discretionary decision for enforcement proceedings. You
Right,
accept my amendment?
Let's see
Yeah,
if,
so just make the record super clear. Does anyone read the statute differently or feel otherwise? That reading those two statutes together, that you do in fact have jurisdiction?
I don't believe we
No,
have jurisdiction.
we already said we didn't have jurisdiction, given those two statutes. We don't have discretionary decision for enforcement proceedings. That's my motion,
Okay.
I'd second.
in
again.
accordance with those statutes as read. Roll call vote, Audrey?
I'm going to agree that we don't have jurisdiction.
Yes.
Kate?
I agree we do not have jurisdiction.
Chuck?
I agree, we don't have jurisdiction.
I also agree that we don't have the discretionary powers for the jurisdiction to enforce. Sabette?
And I also agree we do not have jurisdiction to enforce.
Okay, so that concludes that case. We will not be hearing it.
Okay.
We got lots of time to hear the other cases. Oh, I guess we're continuing them.
Oh, I think I threw my agenda up there. I threw my agenda up there. I had notes on there.
It's time for candy.
Wow. You're good. Jeez.
Yeah,
Okay,
yeah.
so, keeping Michael around.
I'm happy to stay, I'm happy to go.
Do we need him for?
So I think what we should do is maybe such it would be, if we were to keep Michael, it would be for this case.
Yeah, for which, is that the one that this lady's contesting?
No, so this is the one about the class. That we had questions about.
And actually,
So we wanted to for that one.
But we want time.
Are we gonna open?
Do we already,
We're
okay.
going to continue because we want time, Michael, to have time to investigate classics.
There may be so much here.
Oh, all right, then why don't we do this one? And that's,
okay.
that engineer there?
Yes. Not on the agenda.
I've got it right there.
No, it wasn't on the agenda, so it's illegal, and so we're gonna have to renotice it. Yeah.
Yeah, he didn't come in. He didn't come in to do the things he was.
Are we taking a short break?
Wait, I'm trying to figure out something here. All right, so we'll move this up.
Yeah. Yeah, so I think, yeah.
C. All right.
So we could say for the next one.
Okay.
I'm gonna take C up next. Yeah.
That is C. Okay. Okay, so we're going to come back into order here. We've got 1, 2, 3, 4 special exceptions for public hearings. And I'm going to change the order of the agenda so our attorney can sit through special exception C on the agenda, which is Hollenbeck Family Trust, 29 Smith River Road, map and lot 177027, Shorefront Residential District, reconstruction of an existing home to a location outside of the 50-foot buffer, Article 7, Section 175, 55-1, a lot without frontage, seeking a building permit, deeded access over gravel driveway. And I'm going to open the public hearing for this, but first, Randy, state your name and position on this application, and then we're going to have a little discussion.
My name is Randy Tatro. I'm with Norway Plains Associates, and I'm here to help the Hollenbeck Family Trust in their special exception application that's submitted before the board. It's, I forget the section, but it's lots with no frontage.
So can I interrupt for a minute? Do you want to
Yeah, will you
report on the
give us
site
the
visit?
site review?
Just before we get started, yeah. We did in fact have a site visit. It was, I don't have a date, but it was a week and a half ago.
November 20th?
Correct. November 20th?
It was November 20th, thank you. 29 Smith River Road, for the board, we had Kate, Jody, Suzanne, and myself. Audrey later went and viewed the premises on her own. For the applicant, we had Randy Tatro. We walked the premises, and we observed the driveway, and in particular, the section of the driveway that requires a special exception for right-of-way to the road. We left with a good general understanding of the proposed project. Respectfully submitted, Chuck Sumner, ZBA Clerk.
Okay. I think the first item that we have to take up on this application is the private driveway. The issue is the ordinance speaking to lots with no frontage. And 67441, the state law, and our ordinance. Do you have the ordinance number in our town ordinance?
Here too, so it's 675, 55-1.
Okay. Our town ordinance, 175-55, frontage and area requirements, non-conforming lots are exempt from frontage and area requirements. But it goes on to be a little bit confusing. And it says, statement of purpose, in accordance with 674-41, 2A, this section exempts from compliance with the other provisions of 674-41 lots with no frontage and with deeded rights to a private way and lots with frontage only on a private way not shown on a subdivision plat approved by the planning board. 674-41 applies to all lots with frontage on a Class 6 road and lots that do not comply. Well, this isn't a Class 6 road. It's not a road, it's a private driveway. But I think we're conflicted with the state law and our town ordinance. And so maybe Shauna or attorney would like to address this.
So I think what we'd like to do tonight is to open the public hearing and hear from the applicant and make sure we have a clear understanding of the application. But I think At this point, the board has a strong inclination to continue it because we will have some questions for our attorney on the clarity of the distinction between the zoning ordinance and the state statute. Am I saying that right?
Yep.
So I think we can let Randy proceed with.
Yeah, so
the explanation.
basically, we're conflicted with the town and state ordinance, and we're going to need to seek more legal help on that. But
But we do want Randy to speak to the application, correct?
speak to the application and
Sure.
give us a little overview.
Sure.
And then we'll continue this.
Sure. So this property is owned by Hollenbeck Family Trust, a recent purchase about a year ago, a little less than a year ago. It's located off of Witten Neck Road along the state-owned pathway where it intersects Lake Wentworth to the east. So everybody kind of get an understanding where that is. It's right where the trail opens up, where you can see the water on both sides. That's about where we are. So this property, in my research, was created, the original lot was created in like 1898. The larger parcel, they own both parcels. They own another little 50 by 100 parcel that was purchased in, I think, 1908. So those two parcels are contiguous and shown on the plan. And they have existed since then along this same gravel driveway that was reserved and deeded and is subject to the adjoining property, all by deed, since the early 1900s. So it has been used that way. Building permits have been issued on it to the garage and to decks and porches on the existing house over the years. In 1965, the town was granted an easement, for MED, for municipal electric, along with NET for a pole line that runs down that driveway to the existing houses and garage. Again, it's a deeded right to pass over the first about 180 feet. So the first 180 feet is the only section that they don't own the fee in that the driveway sits on. After that, it's about another 280 feet, 300 feet down to where the house and the garage are. So it even says in one of the old deeds that it's 180 feet right away from Witten Neck Road. So because of the lots with no frontage, we've tried to address the criteria that are outlined in that section. Was one part of that, however, that we couldn't do, and we discussed this at the site walk, and that was the waiver forms that are outlined in the section don't exist. They can't be found, and I couldn't find them, and attorney couldn't find them, town couldn't find them. I looked back at a couple of the other ones I did years ago, and they weren't in that either. So what we were asked to do was to do the Class 6 waiver form that everybody does. It doesn't quite fit because it's not a Class 6 road and it's not a private road. E911 slapped a name on it because that's what they do for E911 purposes, but in error they slapped it on both roads. This access road and this access road. Look, they're both given Smith River Road addresses, which is the reason you don't do that for E911. But so that isn't anything I can do about that, and I can't do anything about the fact that the existing driveway is where it is and it's been used that way and plans to be used that way in the future with a new house, and that's why we're here. Some of the criteria that are outlined, I won't go through the application point by point because it's been a long evening already, but generally asks if it hinders surrounding property values, if it's going to be a nuisance differently than a residential use is now, and that's not the case. It's going to be a residential use. It's going to be a rebuilt building, but it's going to be the same thing. Good question, Suzanne?
I have a question.
Sure.
Go ahead, Audrey.
I can't really tell whether, this is technically a road or if it's technically a driveway.
It's a driveway.
To driveway.
It services just those 2 lots, Audrey, nothing else. It doesn't service anything else. I mean, that's the
So
way
does the E911, does the fire department administrate that, or does somebody?
that's a good question. It used to be the town planner, but I don't know where it went since Rob did
So
it.
with, generally what happens in my experience is the fire department says that this has too many structures on it, it needs to be a road, and then E911, they come and they get a road and they name it. But none of that has happened, and we have nothing from the fire department indicating that it's actually a road.
Yeah, well, it used to have a
So-
sign, Audrey, that said
Still does.
Doors Lane or something.
Yeah.
I look back in the old,
But my question is, if it's not a road and it's a driveway, does any of these driveway frontage things even apply?
I guess
They
that
have
would be the
no
question.
frontage. They have no frontage. There's
Okay.
another piece of land in front of,
All right.
off the
Yeah.
road.
We have a denial from the codes officer that, that's what's
Shauna
done.
seems like she wanted to weigh in.
yeah.
Well, I was just going to respond to Audrey real quick and say that I think there is some question. The tax maps also show something different from what is on this plan. And
Tax maps are incorrect in the area with that. It doesn't show those lots adjoining Shanna, but they do.
And just to clarify too, so E911 responsibility was with the planner. It got shifted to Public Works. I don't know that it ever got shifted back to the planner. So the Public Works has been doing that. And we can certainly check to see if there was an E911 process for the Smith Cove Road naming.
And then I have a question too. I can't read, this is so small, and I didn't see a big rolled up plan in the office, and I can't even read the one Shauna's got, so my assumption could be dead wrong, but it looks, well, it's kind of late now. It looks like that you have,
Apologize now, Suzanne.
it looks like you have easements, you've got deeded easements recorded at the registry. Okay, there's 2.
Yep.
It looks like there's 2, and 2 different ones. It's not one of the same, 2 different ones. So I'm asking, can you bring those recorded easements in and make them part of the
Yeah, I
package?
thought I may have submitted one of them.
Oh, I don't have them.
Well, that isn't on me, but
Because I'd like to see what the conditions and terms are of those easements.
I have the easements with me. I can paraphrase them for you. And basically, it says a right to pass and repass with all reasonable uses to the subject premises. It also says on the joining property that it goes over the same thing. In the original out sale conveyance, it mandated that they maintain a reasonable access to that property over that first 180 feet. And I have all those deeds, and I can highlight them and document them, but
Okay, so you pass those in?
sure.
Yeah, thanks. And then, am I correct in assuming that the length of the road, driveway, from, let's just say, that structure that's closest to the main road, is it about 1,000 feet?
No, from this small structure,
Yeah.
it's only 180
No,
feet.
to the house.
To the house? Yeah, it's about 900 feet,
All right, and the width is about 14 feet?
14 foot, 12 to 15, 16 feet. 14 is an average width of the gravel road. You drove down it.
Okay,
Yeah.
those are my questions. Anybody else, any questions? Well, okay, so we've got a ways to go on this to figure out about this driveway. And so I'd like to make a motion to continue the public hearing to January,
Fifth?
what was it?
5th?
5th, 2026.
At 6 o'clock in the Great Hall?
6 o'clock in the Great Hall.
Second.
Roll call vote, Audrey?
Yes.
Kate?
Yes.
Chuck?
Yes.
Ryan, yes. Sabette?
Yes,
Okay, so it's continued to January 6th.
January 6th.
Suzanne, could I ask a question?
What?
I know we've already voted, but what needs to happen?
It's going to our attorney to figure out about
Yeah,
the long
we'll meet with our
driveway.
attorney.
Yeah,
Yep.
I can speak to this a little bit more, like, so I was asked about this very, very recently, and obviously had a lot else to get ready for tonight. And I think a lot of us have some questions about the way the zoning ordinance is put together, and how this particular section is confusing, and we just didn't have time to do that legal review before tonight's hearing. Did I summarize that correctly?
That's what I heard.
Oh, yeah.
Yes.
Yes, yes.
Thank
The board
you.
wants to make sure that they get the right decision.
Yeah, okay, can I just ask one parting question? So, is it something where you may determine that that Class 6 waiver is not the form that needs to be used in here, or is there inherent, did you feel that there's an inherent problem between that and 64139, whatever the erection of buildings on the street is?
67441.
I don't know that there's an inherent, and I don't want to say too much,
Yeah.
but I don't necessarily see an inherent problem. What I see is some questions about what the history was of this particular provision in the zoning ordinance and what its intent was. And so I think that, as well as the language, I think that we want to decipher some of the advice that was given as well, because as you pointed out, there were discussions, and I think that we just want to make sure that we're being fair to your client, as well as the fact that if there's a form that needs to be done that maybe doesn't fit into this box and it doesn't fit into this box, then we can.
I fully understand that. I was at the public hearing when they came up with this ordinance, so I have a pretty good idea what the intent was. That said, these people are trying to submit a shoreline permit, so the rush, if any, in the winter was to get that started. So they hesitated to do that before this, because I wanted to make sure that this phase was taken care of first, so.
And can I just get from the board, doesn't have any objection, obviously, if I talk to Mr. Tatro about that history, that he was, to the extent he has information about that, we could better understand his client's position. I think that would be beneficial for the board.
As long as we get everything in writing.
So if the conversation can be an email?
Sure.
Can I get something from the decision soon enough to react to it for the January 6th? If we do that, probably, right?
Yes.
From my standpoint, yes. Yeah.
All right, thanks, guys. Yeah.
Okay. Thank you, Randy. Okay, so now we have 3 others that are special exception. And let me see what we got going here.
So 2 things, Ms. Chairman. One, do we need legal counsel anymore? And may we dismiss him?
Not at this moment, but I'm sure we're going to need them some more.
You know how to reach me.
But I thank you for coming over.
Thank you, Madam Chair.
And I'm sure we'll be talking. Thank you for your help.
Have a happy holiday.
Oh, yeah, thank you. You too.
And then the second point I wanted to make was that we did receive a request for continuance from an applicant, from an abutter to the 56 Hopewell case. And I apologize, we do have a new admin, and I did ask her, because I'm only on kind of restricted hours, to print off the email requesting the continuance. She did not do that. She instead printed off the email in which that abutter submitted why he was against the case. But I can verify for you that there is an email
Well, you sent it to me. so
from
I
that
can-
abutter
I can,
asking for a continuance because he was unable to be here tonight. And so I just thought it might be appropriate to address whether or not we would accept that request to continue it.
Well, I think we're going to continue all the rest of them. So
Can I ask would we not also have to have the applicant's agreement to continue it? We can't just continue it on an abutters request, can we?
No, we're going to open and continue, but we're going to continue all of these.
I'm asking just a technical process question.
Correct.
Okay.
Yep.
Gotcha.
No, the abutters will all be notified that the continuance is going to take place.
That's not what I was asking, but thanks. I got it.
Yep.
Okay.
But I just wanted the board to be aware of that since it was the last item on the agenda.
And I would add that to administer these applications, not just these, but when we do our calendar for 2026, we have to be very careful that we don't have applications running up against a holiday, because the lead time to get the notices out in the paper and to the applicants and the abutters, in this case, in all of these, did not give the abutters a response time. This particular party got their application notice, I think it was like 2 days before Thanksgiving. So
I understand
I
that,
see no
but-
harm in continuing it. Plus, we have questions on this anyway. So I'm not gonna change the arrangement of the agenda here. I'm gonna go in the order and take number A, new public hearing A, special exception, Kenneth and Christian Brown, 11 Wallace Lane, map lot 25238, Shorefront Residential District. Request for special exception for the removal of a home and construction of a new home with non-conformities, expansion of non-conformity structure by no more than 25%, section 17543A, parentheses 1C. Chuck, would you read the site visit on that, please, that was done November 20th?
Yes, give me just a minute. I was wondering why the applicant is limping.
I hurt my knee, I fell down.
Ouch.
11 Waltz Lane.
11, thank you. I have too many notes in my notes. November 20th, we visited the site. For the board, we had Kate, Jody, Suzanne, and myself. Audrey visited the site at a later date. For the applicant, we had Steve Oles, engineer, and Von Dugan, the architect. We walked the site. The ground was clearly marked with outlines of both the former building and the proposed building. This enabled us to easily understand where old and new buildings were located. We left with a good general understanding of the proposed project. Respectfully submitted, Chuck Sumner, ZBA clerk.
Okay, I'm going to open the public hearing. And Vaughn, would you state your name and position?
Sure, my name is Von Dugan. I am the agent of the applicants, Kristen and Ken Brown. I'm also their architect.
Yeah, pull it down a little. That's it, thank you.
You calling me short?
That's better. So if you go through your application, and then if we have any questions.
Sure. I think you're in receipt of the arguments 1 through 8. I can read them if you'd like. The first thing that I did was look specifically at the provision that we have been called here for, which is 175-43C, which is under non-conforming structures. C is any non-conforming portion of a building or structure may be expanded or extended by no more than 25% of the non-conforming building or structure by special exception. So, and then if you read further, the basis for determining the maximum expansion limitation of 25% shall be the existing lawfully non-conforming footprint measured to the overhang. So if you look at these two large drawings, one is before and one is after, and the small blue area that I pasted on top is the non-conforming limitation, the existing lawfully non-conforming footprint. And you'll see that we have done everything in our ability to reduce the amount of footprint within the 50-foot shoreland setback. And in fact, we have done everything possible to fall under the Wolfeboro shoreland ordinance lot redevelopment. In fact, we have a shoreland permit from both the state and the town. So we satisfied those criteria. So my discussion is going to be just based upon the points that you ask in your application permit. So as far as site suitability, my clients purchased the property from a family. Anyway, they say they purchased their property 5 years ago with the intention of building and retiring in our dream home on Russ Pond. We have always loved Wolfeboro and the surrounding area, and we have a deep respect for the preservation and protection of wetlands and other natural resources. The existing house is on a small lot in the shorefront residential district, and as far as that goes, the state in 2001, and this isn't the prior construction permit for the prior septic system, says that the subdivision was pre-67. We have also submitted a new septic system, and we have approval from the state on that, and you see that on the proposed plan. So the current house was a 2-bedroom Cape-style house with living space in the upper level. The majority of the existing footprint is within 50 foot of Russ Pond. That is the former house. The existing footprint also extends into the north side setback, which was a storage shed. The proposed house is also a 2-bedroom Cape-style house with living space in the upper level. The proposed house has been pushed uphill away from the pond and is an improvement of every criteria in the shorefront zone. It is to be placed up against the front setback on Waltz Lane, and it will no longer be within either side setback. The impervious area within the shoreland setback is currently 1,632 square feet. The proposed encroachment is 969 square feet. That is the impervious area, and as far as I know, not what we are talking about here tonight. That had to do with the shoreland. We're talking about the footprint of the structure, not including decks and porches, according to the non-conforming structures section. So we have decreased the footprint in the shoreland by 40%, from 1,632 to 969 square feet. I think I gave you a copy of the shoreland approval with the packet. I don't know if you got copies of it. Also, number 2, immediate neighborhood impact. The neighborhood of Waltz Lane is made up of non-conforming lots with houses in non-conforming locations. The next door property at 9 Waltz Lane was rebuilt in 2018. It is also in a non-conforming location as a 2-story house. Other lots located on the road have also been rebuilt in a more nearly conforming location. The new house will be consistent with the neighborhood and will have a Cape-style profile suitable to its environs. That's it. So the third point, that there will be no undue nuisance or serious hazard to pedestrian or vehicular traffic, including the location and design of access ways and off-street parking. As you can see in the pre-existing, the existing parking area is in the same location as the proposed, but it has a semicircular wall containing it. It makes it very complicated to park and turn around. The new parking area will be rectangular in shape and accommodate normal turning and parking configuration. So that is a benefit for number 3. There's no nuisance, it's an improvement. Number 4, availability of public services and facilities. The existing house is connected to town water and has an older septic system, 2001, in the same location as the new state-approved chamber system to be installed as part of this rebuild. We also have permits to do that with the state. All utilities and public services will be the same as the existing 2-bedroom house. No change in intensity of use, occupied by the same family. Number 5, appropriateness of the site plan. Consideration shall be given to the following: parking scheme. This is an improved rectangular shape for parking. Traffic circulation, improved rectangular shape for turning around. Open space, there is no change in open space. There is reduction of impervious lot coverage. Fencing and screening, the existing unaltered area to be protected by filter socks and retained. In fact, before demolition occurred, and we have a permit for demolition, Joel, the town employee, came out to inspect the filter sock. It is in the proper location, and he approved it so that we could demolish the building. Landscaping. There is 1 lilac to be relocated, otherwise it meets the shoreland standards. Signage, there will be none. Commercial vehicles, delivery trucks are the same as the existing delivery trucks. And traffic, the same family will be using this house as was using the last house. Light impact, any small path lights will be dark sky compliant. Number 6, immediate neighborhood integrity, that the uses and established use patterns be weighed with recent change trends in the neighborhood. If you're interested, I have a map of Alts Lane with pictures of some of the adjacent properties, just so that you can see them for comparison, if you would like me to share them.
I remember from my drive, so I'll skip that. Got it? So, to summarize, existing trends and uses remain. This is a shorefront residential street as it will remain. Number 7, impact on property values, that the proposed use will not cause or contribute to decline in property values of adjacent properties. If any change in property values occurs, they will be increased. It is a replacement of an older house that is a cape with a variety of additions with a new, more comprehensively designed home, not to mention code compliant. The existing property is not. Stairs, egress, all of the above, insulation, do not match current standards. So the new house will. It is an improvement. The property value of the northern neighbor may have some increase in value caused by the removal of structures within the north side setback. There was a shed within the side setback. It was 4.5 feet away from the lot line. There will be no side setback encroachment at all in the future. Number 8, the proposed use or structure is consistent with the spirit of the ordinance and the intent of the master plan. Of course, I helped work on the master plan, and the most relevant chapter I could come out with, other than the shoreland redevelopment, was population and housing. The town of Wolfeboro should ensure it has ample opportunities for safe, affordable, quality housing for all residents. Therefore, the Brown family should be encouraged to improve their property and bring it up to current building code.
in a location more suitable to the protection of the waters of Russ Pond, and specifically by reducing impervious area, increasing the setback to the shoreline. This structure is located in the shorefront residential zone. The new structure is more compliant with the goals described in 17567D, lot redevelopment, and has a Wolfeboro shoreland permit, which I attached, including 175-64B. The proposed house has a height of 25.5 feet, well below the 35-foot limit. The existing structure has 1,315 square feet of habitable footprint within the shore setback, which seems to be the primary concern of this non-conforming structures chapter or section. The proposed structure has 741 square feet of habitable footprint within the 50-foot shore setback. In addition, the volume of habitable space in the proposed shoreland setback exceeds that of the proposed structure. I don't know if volume is the criteria. I think actually probably the 175-64B building height description is the one that applies. So the site plan is provided by Norway Plans Associates. It has statistics across the bottom of it. I will just hit a few of the salient ones. And I have copies of a variety of permits here that we've already obtained. So some of the facts that I have pertain to shoreland, some of them more to the structure within 50 foot. Before, the deck distance to Russ Pond was 12.7 feet. After, 29 feet, a reduction of 16.3 feet. Before, the house distance to Russ Pond was 21.8 feet. After, it is 39 feet. Pushed back basically 17.2 feet away from Russ Pond. The house to the sideline setback was 4.5 after 15 feet. The habitable space within 50 feet was 1,315 square feet. Currently, the plan is for 471 square feet, a reduction of 844 square feet within the shoreland setback. The big change, actually, the thing that we did to try and get this house away from the lake or the pond, is we pushed it right up so that the overhang is just within inches of the front driveway and road frontage. So we've gone as far as we can away from the lake, or pond, sorry. The impervious area within 255 feet was 30.27%, is now 26.34%. One of the things, the only thing I can think of that is different substantially between this house and the last is the fact that it will be taller, and most of that can be attributed to the fact that across the distance of 126 feet between the lake and the road, there is an elevation change of 19 feet. So when you push a house back from the lake, obviously the first floor goes up the hill with it. So pretty much every lot around most of the lakes in the area will have an increase in height if they comply with the desire of the shoreland plan that ordinance that Wolfeboro has. And I can answer lots of other questions.
I have two.
Well, we're going to have the, anybody else want to speak either for or against this, against it?
Well, it's a technical question, so it might...
No.
Okay.
Anybody wants to speak for or against this application? Yeah.
Hi, thank you for hearing me. My name is Keith Simpson. I'm a resident of Russ Pond, but I'm also a board member of the Russ Pond Association and a past president of the Russ Pond Association. And that's why I'm here tonight. It's just sort of a due diligence that I'm doing for the association, and I welcome any new people, and whatever you decide will be fine. The only thing I would like to interject or put up for consideration is that this particular area of Russ Pond, I forgot to mention, I also have been sampling the water for over 20 years, maybe 25 years on Russ Pond. And I'm not a water quality expert, but the quality of the water is very important to me, and that's why I volunteer for this. At any rate, this particular piece of property is between two sort of trouble areas. One of them is Route 28. I don't know whether you're aware of this or not, but it's like at the top of the list in the town of a trouble area that needs to be dealt with, mostly due to runoff, especially salt in the winter. And that's on one side of this property. On the other side of this property is what we call the north end, which we've had continual trouble with from runoff starting up at Brewster Heights and even the high school that has created a delta in that end of the pond. So it's something that we've been trying to deal with various grants and have had some success, but it still continues to be a problem. And I just would like to offer that, which you're in your wisdom, you can weigh that in with your decision in this case.
Thank you. Thank you.
Okay.
Vaughn?
You got a question?
No. I would ask Vaughn if she could address that concern.
Well, one of the things we worked hard to accomplish on this project was to pull the house as far back from the lake as possible and not reduce any of the structures right on the shore, any of the vegetation along the shore. The filter sock is in place. This project should not have a negative impact. Hopefully, if our shoreline ordinance is correct, it will have a positive impact. There will be more space between the roofs and the water. Also, we were not required to, but we added an infiltration trench around the house because of the nature of lot redevelopment in the shoreland ordinance. This was a reduction in square footage, and we were not required to have a water management plan, but despite that, the infiltration trench was added. So, and in addition, my client Ken is an avid fisherman. I think he is very concerned that this not impact the lake at all.
Okay. Board members, questions?
Yeah.
Could I jump in for just one? I just wanted to address what you just said.
Probably the same thing I was talking about.
Okay.
Go ahead, Chuck.
In the approval you got from the Lakes Region Planning Commission, you actually mentioned that there is a total of 3% reduction in impervious surface area. So that it's slight, but there is a slight increase, a slight net increase in permeable soil on the lot.
Correct, and we accomplished this by making the predominance of the drive area that is now rectangular, helpfully, pervious.
Okay, thank you. Sorry.
Audrey?
Yeah, so the drip edge, which I noticed is, substantial and meant to take the roof water, and the pervious parking area, are, I want to say, upgrades to what is required. And I see they both are, go down to 18 inches. Is that the point at which it will then naturally go down into the ground itself, even during winter?
It should, and actually, Randy is not still here, but it's his staff that put that detail together. So but yes, that is a standard.
Okay. I see a note here that part of the lot is in the flood zone. I'm assuming that the house is not?
Not at all.
Okay.
No.
And the area that is the old house is being removed from, I think the notes on here say those areas are being turned into lawn.
Yes.
Is there a reason why they might be not more naturalized?
They may be. We weren't required to, so we're putting everything on this plan that we were required to submit, and that's, except we added the infiltration trench.
Gotcha.
But I'm sure that my clients intend to plant the area with natural plants. We just don't have a planting plan.
And then my last question is the the waterfront approval says that it's good for just a year. Is that a year to what? When you start the project, when you finish the project?
The Wolfeboro?
Yeah.
Well, you might ask Shanna.
The shoreland permit?
Yeah.
So the shoreland permit is an administrative permit, and I think there's a citation in there for a portion of the zoning ordinance that says any administrative permit is only good for a year and then must be renewed. And so
Okay.
we were finding, when I started, shoreland permits that were 10 years old that people were trying to then build houses on, and so we have started enforcing that.
So when you do that, do you reevaluate everything, or do you make sure they're doing what you originally required?
No, if that shoreland permit expires, then it gets relooked at, but under a new ordinance, should the ordinance change. Yeah, it will have expired.
So it gets looked at under a new ordinance, and this permit's no
Yeah, I
longer
mean,
active.
I suppose they could come in and ask for an extension. We would
Yeah.
probably look at an extension the way any other board, and it's an administrative permit, so
Yeah.
whoever's in charge
It
would.
seems weird to maybe change the benchmark or the threshold in the middle of a project for certain things.
Yeah, and so I think, I don't remember the exact language. If you give me the citation, I can find it. I have my code right here.
175, 186C.
I think the way that we interpret that is that they have to have the building permit in hand and be moving with construction on the building permit. It does not need to be completed.
What's the date on that, Audrey?
This was in September, I think.
September 4.
86, sorry. 175, 86, you said?
175, 186C. And how long is a DES permit good for? Do you know? Oh, shorefront permit.
I want to say 3 years.
Yeah.
Yeah. So the way that, so 175, 186 is permits, and it talks about building permits, and then it talks about sign permits, and then section C is a permit is valid for a period of 1 year from the date of issue. Period.
A permit.
Yeah. So
Okay.
yeah.
I don't have any more questions, maybe some comments, but. Kate, you got a question?
No, I don't. Thank you.
Anybody in the audience?
I have a
any-
question.
Oh, you do? Go ahead.
You gave us areas for the change in footprint that's within the shorefront area. What's the total footprint of old versus new? I don't see that anywhere.
So I do have it.
I did read that someplace.
If it's in the fine print, I can't read it.
Yeah.
No. I can see an outline, and I see the numbers for area within the shorefront. I don't see total
Yeah,
footprint
Actually, I
area.
don't think I brought that with me. I was thinking we were addressing only the area within the shoreland setback
Yeah. okay.
because of the way that the non-conforming section reads.
Yeah, we
And I would agree with that.
we debated that just a short while ago.
Yeah, and I
So-
apologize. I do agree with that. This is the way that the ordinance reads. It's any non-conforming portion of a building
Okay.
or structure, and our legal counsel has let us know that they believe that that means the non-conforming
Portion.
section of the building
right.
over the 50-foot line. It then goes on to say, may be expanded or extended by no more than 25%.
Just that portion
Just
maybe.
that non-conforming portion. So
Maybe.
you
The
can,
blue.
you can see that that
Right.
is the light blue piece of the new building is the only piece that the ZBA
Right.
really is
No,
looking at tonight.
I do get that, and I do
Yeah.
see the numbers.
Yep, yeah. So I apologize. I don't think I explained that right when we talked about that earlier.
Thank you.
Yes.
For a visual, the darker blue is existing, and the lighter blue I just put on top of it.
Oh, okay.
Same location, big reduction.
Thank you. Nice job.
Any further questions? Any further questions from the audience? Seeing none, I'll make a roll call vote to close the public hearing. Audrey?
Yes.
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 Ryan, yes. Sabette?
Yes.
Okay, so now we go through the 8 points. Number 1, site suitability. The specific site is an appropriate location for the proposed use or structure. It has adequate usable space, adequate access, absent of environmental constraints, floodplains, steep slopes, etc. Comment on number 1? Does it meet A, B, and C? Which is adequate space, adequate access, absent
Yes.
floodplains and steep slopes.
I think it's actually much improved on those 3 points over what was existing.
I agree.
Yes.
Okay. Number 2, immediate neighborhood impact, that the proposal is not detrimental, injurious, obnoxious, or offensive to abutting properties in particular and to the neighborhood in general. Typical impacts which extend beyond the proposed site include excessive trip generation, noise, vibration, dust, glare, heat, smoke, fumes, gas, odor, inappropriate hours of operation. I would say that they do not impede any of those.
It's exactly the same use as before.
Exactly, yes.
And the parking is improved.
Oh, good, so now I don't have the next section. You got one of these applications? I don't have the whole thing. I got number 2. The 8 points, I've only got up to
Yep.
number 2.
Number 3 was,
Number 3, there will be no undue nuisance or serious hazards to pedestrians or vehicle traffic, including the location and design of access ways and off-street parking. I'd say
it's improved.
it's improved, if not the same. Okay?
It's
Number 4,
improved both in function for driving and in adding to the filtration of water from impervious areas.
okay. Number 4, availability of public service and facilities, that stays the same, nothing changed.
It's getting a new septic system, which is an improvement.
Number 5, appropriateness of site plan.
It
It checks all the boxes.
checks all the boxes.
Number 6, immediate neighborhood integrity.
It will,
It's about the same.
yes.
Okay. Number 7, impact on property values. We haven't heard one way or the other on that. So
Well, it's going to be a new structure. It should be a little bit improved, and they're taking out a shed.
yeah, okay. Number 8, the proposed use or structure is consistent with the spirit of the ordinance and the limits and the limit of the master plan.
Yes, it takes a lot of steps to improve water quality while still providing housing.
Hopefully improves the drainage there.
Improves the drainage.
Okay, I need a majority vote on this. Well, I'd make a motion to approve case number, my agenda. Case number, on map and lot 252-38 for Kenneth and Christian Brown, 11 Waltz Lane. No case number.
No
For
case
section 175, 43A1C. With conditions which are, all federal and state permits shall be received prior to construction, including but not limited to the town of Wolfeboro building codes. 2, the approval is per all the documentation submitted, no date on here, submitted 10/23/25 is the official documentation. Number 3, the application as submitted to the ZBA does not satisfy the substantial requirements for the building permit or a site plan approval. Number 4, the notice of decision shall be recorded at the Carroll County Registry of Deeds, and the applicant shall be responsible for payment of all recording fees. Number 5, this special exception shall be valid if exercised within 2 years. I think the new law just changed to 3. But 2 years from the date of approval, or as further extended by local ordinance or by the Zoning Board of Adjustment for good cause, in accordance with 674-33, Roman 1AA. Number 6, appeal process. Pursuant to RSA 6772, an aggrieved party may appeal this decision to the County Superior Court within 30 days of the date the board voted to approve or disapprove this application, and or in some instances, the Housing Appeal Board, which is 6774 and 67715, and or 6776. 7, if there is any significant change to the site plan proposal, the applicant shall return to the zoning board.
Did you want the date on that, or is that assumed?
I gave this
You did?
date.
The date of the site plan was 10/7/25, the latest revision from Norway Plains.
All right, well, let's see, what did I just use? I used the one that, I used 10/23/25. What did you have?
Is that the application?
That's the date of the application.
The date of the site plan, the last revision is 10/7/2025.
Oh, okay. All right, did you get that? Okay. Well, and it's also the date of the application. This is the material that is going to be used as the official documentation.
Okay.
It's not so much the site plan, but, okay. Put both dates down and then we're covered. Do I get a second to the motion as
Second.
amended with the conditions?
Second.
Chuck seconded. Roll call. Audrey?
Yes.
Kate?
Yes.
Chuck?
Yes.
Ryan, yes. Sabette?
Yes.
Okay, yeah, Vaughn, you've got your approval. Okay, so.
Can we determine
Next,
whether
what-
the Hopewell
Well,
point
wait a
one
minute,
will
wait a
be
minute.
continued?
Please, wait a minute. Why are you doing that one? We haven't done B.
Because, the reason I'm asking is because if that one's going to be continued, and we haven't decided that yet, there was a request from a neighbor, maybe we can hear this other one, but if that one's not going to be continued, we have 2, And honestly, I'm getting a migraine, so I would rather, if we have to have two, I think I might like
Okay,
to
so
continue them.
we'll just be a minute. We'll open and continue this, as you asked, D, special exception for Warren and Jennifer Wilson.
But we need to have the applicant's approval of the continuation because the request was by a neighbor.
Because of the 90 days, so the request for continuance was from an abutter.
Yeah.
So we still have the 90-day clock. by
Okay,
the
so
applicant.
let's ask, I see you're the presenter. Will you accept a continuance on this before we get going?
If it were just up to me, I would say yes, but I know my client would strongly object. This is a project that was initially permitted by the town of Wolfeboro. He began the process and then a neighbor complained, which then rose the issue of the special exception need in the first place. And so my client would strenuously object to having this continued.
Yes.
He needs this to be heard.
Yes, you're saying yes?
I'm saying
no.
No. All right, well, then we're going to go in the order of the agenda, and you may get continued anyway. Okay, in the order of the agenda, B, special exception, Sebastian Tornado, 124 Oakwood Street, map lot 25947, Shorefront Residential District. Request for special exception for the removal of a home and construction of a new home and placing a roof over a portion of a deck with nonconformities. Expansion of nonconforming structure by no more than 25%, section 175-43A1C and 175-43A1H, special exception for the roof over a deck. Hi.
Hi.
Site plan?
So my name is Sebastian Tordonato. I'm here to
Suzanne.
seek a special exception permit for 124 Oakwood Road.
Sebastian, I'm sorry. Chuck, would you read the site visit that we did on November 20th?
Two things. First of all is, Audrey, you're going to be okay to hear one more case?
Yeah, I get spots, so I'm not in pain, I just can't read anything.
Because you were turning red a few minutes ago, and I was
That's because I was mad.
Oh, okay.
No, I don't know. I'll let you know if I pass out.
Thank you.
I'm planning on at 9 o'clock shutting it down, so go ahead,
All right.
Chuck.
124 Oakwood Road. On November 20th, from the board, we had Kate, Jody, Suzanne, and myself. Audrey visited at a later date, yesterday, I believe.
Yes.
For the applicant, we had Josh Bork, engineer, and Sebastian Tornado, owner. Tordonato, correct?
Tordonato.
Thank you. We walked the site, we observed the location of the current building and the new proposed building. The objective is to tear down the current home and replace with a new structure that is 35% less non-conforming. We left with a good general understanding of the proposed project. Respectfully submitted, Chuck Sumner, ZBA clerk.
Okay, thank you. I'm going to try to be quick because I need to be home by 9 o'clock too. So I've submitted the application and I've submitted the site plan. The site plan was done by Norway Plains, and the highlights of the application are that we're seeking a special exception for expansion of the structure in a non-conforming area and the roof over the deck. Overall, the current building has non-conforming areas which add up to 741 square feet. With the redesign that we're doing, we are going to make the structure less non-conforming, and the proposed total non-conforming area after the redesign is 476.6 square feet. So we have a total reduction of 35.7% in the non-conforming area. And that's on the drawing there. Do you have a question?
I'm not seeing the difference between what you're asking for and what's there.
Okay, so you have 3 drawings. It's on this drawing here.
I do.
The one that has the proposed.
So I
we only have
only
one.
have this one.
That's the current house. Okay,
That's the only plan you had in your file?
That's the,
I'm sorry, the only plan you had in your
this is the
packet?
only plan that came in my packet,
No,
which
we got
is,
this.
Yeah, same here.
This and that.
Well, good thing I brought this.
Yeah, no, we only have one sheet with the new.
can you go back to the podium, please? I
Great.
think what I want to do is I want to, since I hadn't had a chance to review this, I would like to continue this to the next time so that we can get a copy of this and review the changes.
Yeah, so oddly enough, I have the proposed conditions and not the existing conditions in the file. So
Okay.
I would love a copy of the existing conditions
I've got
back.
the existing one.
And I can make you copies of the proposed.
Thank you.
So could I make a motion to continue?
Okay, so I'm going to give you 2 choices. Next Monday or January.
So we are not coming back next Monday for anything yet, right?
Well, I wasn't planning on coming back for anything except January 5th, but we do have the availability of next Monday.
So I don't know, I think this could be continued for a month.
You think what?
It could be continued to January 5th.
Okay, so are you making a motion?
Yes.
Make it.
I would like to make a motion to continue this to our next meeting on January 5th at 6 o'clock here in the Great Hall in order to get paperwork to review that I haven't had a chance to look at.
Okay. Second. Roll call vote.
Audrey, yes.
Kate?
Yes.
Chuck?
I presume it's okay with,
Well, it's our decision, Chuck.
it's our decision.
I don't think my opinion matters, but for the record, no. But
All right.
it doesn't matter.
I can't review this right now.
Yes.
It would take me a half an
Yes.
hour.
Ryan, yes. Sabette?
Yes.
It's not your fault.
Okay, you're continued. And so then, we're all set, I'm sorry.
Okay.
The other item on the application will be the same thing. We're going to open it, and I imagine if the board votes, we'll continue it. And that was special exception for, and that's D, special exception for Warren and Jennifer Williams, 56 Hopewell Avenue, map and lot 228-39, Shorefront Residential District, rebuilding expansion of a residential dwelling and deck, shifting away from the shoreline, increasing the footprint less than 25% while adding a second floor, section 175A1C, H, and J. Chuck, will you please read the site visit from November 20th?
Thank you for asking. On November 20th, for the board, we had Kate, Jody, Suzanne, and myself. On November 20th, Audrey visited at a later date. For the applicant, we had Nick Luganis, builder, and Steve Oles, engineer. We walked the property and observed the locations of both the existing and the proposed buildings. We saw the constraints of the shoreline setback, wetland setback, and the septic system to pretty well tightly constrain any new construction. We left with a good general understanding of the proposed projects. Respectfully submitted, Chuck Sumner, ZBA clerk.
Thank you. Okay, I'd like to open the public hearing to take testimony. State your name for the record and who you represent and what your goal is.
Good evening. My name is Attorney Philip Marbury here on behalf of the applicant Warren Wilson. And I can make this extremely brief. Having submitted everything in detail, I'm happy just to do a super quick highlight if the board will permit me, and then address any questions that the board may have. Each of you should have 2 drawings that were submitted from Norway Plains Associates. The first is kind of a general site plan that demonstrates the overall footprint of the existing and proposed, and then we also provided a second one that breaks down the numbers for each of the special exceptions that we are requesting. And again, just for clarification, we are requesting an expansion under subsection C for a horizontal footprint expansion of less than 25%, under subsection H for it's actually a reduction in the overall deck that's non-conforming, but because it didn't quite fit in any other place, H is the place that goes. And then J for a vertical expansion to add a second floor to this very, very small unit there. Again, it complies with everything that's required for the special exception. I've outlined in details all of the different bullet points and the specific requirements for a special exception. It's pulling us further away from the shoreline as much as is possible. And again, I can go into all the details, but if you look on the page that has the 5 different diagrams on it, the first top left corner diagram there it shows the existing footprint and specifically shows the amount of square foot of the existing footprint that is in the setback. And there's a total of 685 square feet measured to the drip edge that's in the existing footprint in that shoreline setback. There's also a total of 250 square foot of deck that is in the non-conforming portion in that shoreline setback. The very next drawing to the right is the proposed building, and you will see that there is a total increase of to a maximum of 740 square feet, which only comes to a 5.25% increase in the actual horizontal footprint. So that, again, complies with the requirement under subsection C that it be less than 25%. That is a total of 55 square foot increase in the setback area. But you will notice that the overall has been pulled back from the shoreline. And if you look at the drawings below, the 2 drawings on the bottom, that shows the existing overall footprint of the building and then the proposed overall. And that final drawing to the far right shows them overlaid on top of one another. And it shows that it has been pulled back from the shoreline a little bit. The deck itself has been pulled back more significantly, and that is demonstrated on the other plan that you have before you, which shows that the proposed deck is being pulled back let me make sure I can read this well, 1.77 feet further away. Now, this may not sound like a significant move, but considering how tight this lot is and the areas that are within all of the setbacks, this is the maximum amount that they could without starting to infringe on other setback areas. And so in light of how small this lot is, I would argue that a 1.7 feet withdrawal away from the lake there is a significant and a marked improvement. This plan will also allow a new septic system to be placed, a new well to be placed, all that already have New Hampshire DES and Town of Wolfeboro shoreline permit approval. The impact has already been approved by New Hampshire DES. And so the only thing that remains is for this board to grant the special exceptions. And I believe that I've quickly, but hopefully illuminated more by all of the written materials that was provided to the board, demonstrated that we have complied with all of the requirements for those 3 special exceptions. I'm happy to take any questions, but I don't want to just belabor and keep you here later than you need to.
Is there anybody from the public that would like to speak to this application? I see one party over here. Please come forward, state your name for the record.
Good evening. My name is Irene Bascuñana. I'm an abutter at 58 Hopewell Point Road. Okay. And yes, my husband had requested a continuance because we just got the notice during the holiday, and he is traveling at a conference for work. So we didn't have a lot of the information, okay? So that's what we had requested, okay? Some of the information that's missing, should I address some of the information that's missing?
Yep, can you put the microphone?
Oh, sorry. Do you want me to say that again?
No, just that last part.
Oh, so some information was missing because, we just, got notice with the holiday. And so should I ask what some of the information that was missing?
Yes.
Oh, okay. Okay. All right. Well, we wanted to ask for continuance because it's the right to know. Like, a lot of the information is not in the public domain. It's sort of hard to find. Okay, so like point F, all existing buildings or other structures with their dimensions and encroachments. Well, for example, like the garage dimensions are missing, and that's the second floor with windows. That could be livable space. Okay. G, all proposed buildings, structures, or additions with dimensions and encroachments indicating proposed on the plan. Dimensions and drawings of expanded vertical house, that's missing. We don't have the architectural drawings for the proposed, vertical expansion for the house, okay? The overhangs are missing, which affects the impervious, which affects the water. H, the zoning envelope made from setbacks required by zoning ordinance. Indicate zone classification. All setback dimensions. Indicate zone change lines. For example, the side setback to the butter, to us, is missing. J, location and numbering of parking spaces and lanes with their dimensions. Indicate how required parking spaces are computed. This is not included and especially is needed as an active Airbnb. K, dimensions and directions of traffic lanes and exits and entrances. This is not included and especially is needed as Hopewell Point Road. It's a dead-end, one-lane private road. L, any required loading and unloading and trash and snow storage areas. This is needed as used as an active Airbnb or short-term rental. Okay. All right. So the main thing we're opposing is well, there are several things that are not, we don't have enough information on, but it's mostly the vertical expansion that exceeds the 25% increase. It goes to 200%. Okay.
Anyone have any questions, sir?
So if I may, this packet that I passed out is from this applicant and outlines a number of concerns, it appears, regarding the proposal. So I just wanted to point out that that's been submitted for the record.
Where did that go?
Right.
Well, we haven't had a chance to look at this.
Right.
It
Right.
came in at 12:36 today. So,
Need a little time for that, I think.
is there any information that you don't have in front of you that you would like more explanation on?
Yeah, you can come back up after a minute here.
You're all set, thank you.
Oh.
Was she that person?
Phil, could you repeat that to the microphone? So I missed it.
I'm happy to address some of the things that she raised as well. The first one that I heard her raise is that it doesn't show the drip edge. All of the surveyed plans that you have are drip edge to drip edge for both previous and proposed. So that is the measurement that the surveyor used, clearly understanding what is required. She also raised a lack of knowledge about the height of the building. The building will comply with the Wolfeboro Town Code, which requires a maximum of 35 feet. The maximum height of this building will only be under 25 feet at its highest point, even with the vertical expansion that's being requested. It's a mono-sloped roof, so it's single point, and the highest point of that roof will be under 25 feet. And so again, well within the requirements of the town of Wolfeboro for the height restrictions per the code enforcement.
Clarification on that point is how much taller is it than the existing structure?
I don't have that right off the top of my head, but I don't believe it's much taller because the existing structure is a single story with an attic. And so there is a space up there. And so it's marginally taller, but it adds that second floor. There's not an additional attic space. Again, it's a monosloped roof sloping down from the highest point on one side all the way down to a lower point on the other.
Does it slope away from our neighbor here or towards our neighbor?
I could speculate, but I don't know off the top of my head, and so I'd rather not misrepresent that.
I gather, I've just scanned this, I gather that it looks like her interpretation of the plans is that she's going to be looking at a very tall wall of windows.
I did notice on the site visit that a lot of the houses right along this side of the road, there's a very steep drop off. So like the garage height, many of them have filled in between the road height and the way to get into the house. There's no grade line shown on this. Is this a reasonably flat lot, or is this quite steep? I'm sorry, there are grade lines, but not very many.
Yeah, I think it's relatively flat based on just my reading of those grid lines. And again, the garage wasn't addressed at this because the garage, they were able to fit entirely within the setback requirements. And so the garage will not be non-conforming. The garage that is proposed, it fits nicely into that bottom right or bottom left corner of the setbacks. And so it will not be non-conforming.
So is the garage being left or is it being rebuilt?
I actually think that, I don't know. My understanding is that was either an existing garage or being built to be conforming there, so it wasn't part of the application for special exception. So I don't know.
It looks like that it is actually within the front setback entirely, so it must be existing. If I'm seeing the setback lines.
You are correct. That's an existing garage, and it's staying. No changes to that.
That's what that was
the
my
thing that's being
interpretation.
added is the new septic system there.
Okay. And yeah, as I remember, Audrey, it was just a very short step down from the road down to the property.
Okay.
Pretty gradual change in slope.
Chuck, really quick, backing up to your questions, did you want the applicant to submit information to address your questions about building height? Because the answer was, I don't know.
Yes.
Well, I'm asking on behalf of the abutter to clarify what her view is going to look like.
Okay.
So, yeah, orientation and height specifics would be useful, yes.
And the roof pitch, you asked about the roof
Yes.
pitch too. Okay.
So what is our zoning with regard to expansion on the second floor within the setback?
Yep. Write this down.
That's just the special exception, no limit?
A structure may be expanded vertically within any setback above existing non-conforming footprint beyond the 25%, but must obtain a special exception from the ZBA.
So in this case, if I have the setbacks correctly, there's a section of the building along that lot line that's a narrow strip of the building that's encroaching on the setback. So that is the only area that would be added for the expansion is the area above that and not above?
No, and all of the area of the building
within
on
the
the
50
water
feet.
side of the 50
Okay.
feet. Yep.
Yeah.
But to clarify, that provision is not calling the board to make a determination of 25%. It's
Right.
language that is confusing, but it's simply saying any vertical expansion requires the board to grant a special exception.
Right, and the special exception, to your point, one of the aspects might be what impact is the height having on the neighbor? And that would be a good question. I think I'd like to know that as well.
Okay, Audrey, you got your questions? I can see that the abutter is anxious to comment. Can you hold that question or thought?
Well, we don't have that information, so.
Okay.
Yeah.
Microphone.
Oh, I have some photos. I'm not sure if you got the photos as well.
They got the whole packet that you sent.
They got that.
But we haven't had time to look at it.
Because it just
Right.
came in this morning, so
Right,
they,
right.
they got it at the meeting tonight.
Okay, so I made a mistake. I printed out 11 by 14 instead of 11 by 17, okay? But before we go to that, in reference to the garage, that was added by this current owners, okay? There was a small, like, tool shed like the size of me, and that got removed, and instead we got this gigantic, as you saw, that gigantic garage, 2-story, 30 feet tall, 10 feet from the road.
Did it?
Okay, and I wanted to know the exact dimensions because we don't have that because there's living space in that second floor. You also have windows overlooking at us, okay? But here are the images I wanted to show. So here you have the current structure. And then from what I understand from when I met with Mr. Scott, September 24th, he informed me it was going to be not just 25% increase, but 200% increase, okay? So you can see the size is going from, whoops. Hold on, whoops, excuse me, one second. Okay. So the non-conforming, the 25%, the current size of the house is 993 square feet. And with the increase, with the second floor, it's 200% increase, 2,961 square feet. There's also 8-foot overhangs all around that go into the setback, okay? Give me a second. Okay. 1, 2. The lot is already overbuilt. With the 2-story garage, which is, it already exceeds the lot ratio, it was at 30%, and putting in that garage, now the lot is already beyond the town limit. It's at 34%. And that's according to Norway Plains, to their drawings, okay? That's not including this new expansion of the house. Then the existing 2-story garage has an upstairs room with lake views, okay? You see it here, okay? So when they have the lights on, it lights up our yard. It's like it's like being in a football stadium, okay? And it also takes up our privacy, okay? So the question that Mr. Summer rose, which is correct, the existing non-intrusive structure, okay, the current house, you see it's 1 story, and the roof is slanted, so there's no problem right now, okay? But then if you add that vertical expansion with all those windows and that excessive height, I think the height might be maybe, 14 feet, so going up to 25 feet, okay. I mean, and also the setback on our side is only 5 feet. It's not even 10 feet. So it's just so close, okay? We also get the noise. So we're just asking to keep the same height. Keep the same height, okay? All right, hold on. Oh, then the huge new structure, it's not fitting in with the structures of the budding properties, okay? If you look at the roof line, the one to the left is, it's 44 Hopewell Point. That is a 1-story boathouse to the other neighbors, and then there's wetlands, okay? Then you have the house to 56, which is 1 story, and then their garage in the back, and then to the right is ours, which you saw is a 1 story, and we have no garage, okay? All right. Okay, hold on. So if you, So if you change the roof line, then you have it, 1 story, then you're gonna have like this, triangular, it doesn't match the 2 abutters, okay? All right. The other thing we were gonna mention is that there is a safety issue. A Hopewell Point Road, as you saw, it's a one lane dead end road. Okay, it's also a private road. Okay, so for any emergency, like the fire trucks, okay, like the older seniors at the end of the road, they do the morning check the well check with the police officers. If they need an ambulance or a fire truck, they can't always get through because the 56 uses it as a short-term rental, and often the cars are parked, on that private road, and there's no space. There's no space. So it's a major safety issue, okay? Now, we put in some parking rocks, we put in a chain, but we still have people turning around in our driveway. And then what happens is then they go up to the next home, and then now they put, some type of, so people don't go in. But the pain is that it's not set up for, so much additional traffic. Now, just to give you a little bit of background about this house was that the reason it's so small is that it initially was the boathouse to our property before my time, okay? So Mr. Hopewell, he gave the boathouse to his secretary, okay? And Mrs. Basili, and she used it for 50 years with her family, and we lived next to them, and there were no problems. There was no problems, okay? Then the new neighbors came, and they, built this garage, and then it's used as short-term rental. There's a lot of noise, the safety of the road, and so I think this vertical expansion just adds to, more noise, and it's not consistent with the rest of the neighborhood, okay? Then, the other thing is, it's on the designs initially that were done with Norway Plains, December of 2024, they show of the house, okay? But the house design has changed now in October. It doesn't show the impervious, from what I understand, okay? So in this document, okay, the written document, am I past 9 o'clock? Okay. If you go through, because I went through the 8 points, okay, to the best I could, the impervious is with the overhang, that caterpillar overhang. Here. It's going, it's going to 236.7 square feet in addition, okay, of the impervious structure. And that's not allowed, okay?
So I have I'm pretty good with numbers and you're losing me. So, primarily because, you've given us a package that I haven't had a chance, none of us have had a chance to review. So I guess the question before all of us is, are the questions raised sufficient to cause a continuance?
Yes, I believe so.
I'm not ready to make a decision on this.
Okay, so I would make a motion because we need more information and we have to try to explain what information we want, that we continue to January 5th, 6 o'clock here in the town hall.
Second.
Perfect. Thank you.
All those in favor?
So what information are we requesting from you?
Well, we're going to get back to that. Just get the motion passed. All those in favor?
Yes.
Audrey? Aye. Chuck?
Yes.
Kate?
Yes.
Myself?
She said
Sabette?
aye. Yep.
Okay, now, will somebody define what it is that we'd like the applicant to give us? Or some of it?
Primarily elevations.
I've heard roof pitch, height, and then overhang versus footprint were the three.
So,
Yeah, we're all done with public comment now.
Sorry.
Yep. You will have a chance at the next meeting.
I guess I would like to send in some requests for more information to
why don't we
you that you
do
could
that?
pass it on after looking at.
Okay.
Because I don't even know what to ask either.
There's part of a driveway being removed. Is that part of the trade-off for impervious? I just can't tell at this point.
I'm thinking I need to
We
make
don't have to
another...
specify every iota. I think to send stuff into Shauna is a good idea, and then she will let the applicant know.
So is there a
I would
building
like to do
permit?
another...
I don't know.
I would like to do another site visit myself. I'd like to see it again.
Well, yeah, you're welcome to.
You can always do that.
From the road? Yeah.
So if I could just ask if you guys could get me kind of that list of what you want in the next couple of weeks, just with another holiday coming, I want to make sure the applicant has enough time to turn around new plans.
Yep.
Okay, so I believe I made the motion and it was seconded and it was voted to continue.
Yes.
Yep.
Is that, Leanne, am I right? I'm done. Okay, so the hearing is continued to January 5th.
This one and
And
this
any written information is welcome. Okay, as far as anything else on the agenda, I am not interested in entertaining anything else, so therefore I would make a motion to adjourn.
Suzanne, before you do that, do you want to do the second reading, or?
No,
No, okay.
can wait.
Then I second your motion for adjournment.
All those in favor?
Aye.
Thank you, Sabat.
Thank
Good
you,
night.
Sabat.
Sure, thank you guys. Bye.
Bye, thank you.
Did our technician leave already?
What?
No, he's up there.
did. I did see.
He looked, our camera guy looked.
I don't know. Oh, there he is.
Suzanne, I meant to ask you about this earlier. This email came from Matt Surge
Yeah.
about the Murdoch case, so he wants to sit down and talk to us.
Oh, that was, Poplar Island?
Is that what Murdoch? I don't even know, to be honest with you. I haven't had a chance to look.
I wanted to